See hope and optimism. People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year. For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past, far-reaching gun law in the history of the world, it is not. But they actually did it.
Functions exactly the same. As fast as you depress the trigger is as fast as a round comes out. E320, which some of you probably saw in one of the hearings on the magazine bans, I showed my.
Recently, the U.S. Supreme Court denied an emergency review in the case of Gazzola versus Hochul, a lawsuit challenging New York's Concealed Carry Improvement Act and its ammunition restrictions, particularly the requirement for background checks on ammunition purchases. This denial is significant for arms rights advocates and residents in states like New York and California, where stringent arms control measures are in place. The Gazzola case emerged as a direct response to the New York State's passage of the CCIA. This law was enacted following the Supreme Court's decision in New York State Rifle and Pistol Association, Inc. versus Bruin, which struck down New York's earlier restrictive concealed carry laws. The CCIA imposed new regulations, including more rigorous background checks for both arms and ammunition purchases. The plaintiffs in Gazzola argued that these measures infringe upon their Second Amendment rights by making it unduly difficult for individuals to acquire arms and ammunition. The Supreme Court's refusal to grant emergency review to Gazzola marks the second time it has declined to intervene at an early stage in this case. This denial leaves in place the Second Circuit's decision to uphold the lower court's refusal to grant a preliminary injunction against the CCIA's ammunition restrictions. Preliminary injunctions are temporary measures to halt a law's enforcement while its legality is contested in court. While the Supreme Court's decision is a setback for the plaintiffs, it does not signify the end of the legal battle against the CCIA. The denial was specifically for an emergency review related to a preliminary injunction, not a final ruling on the case's merits. The lower courts will continue to handle the substantive challenges against the CCIA, which means the case is still alive and may return to the Supreme Court in the future. Additionally, the Supreme Court is currently considering another significant Second Amendment case, United States versus Rahimi. This case involves the constitutionality of federal laws that restrict arm possession by individuals under domestic violence restraining orders. The court's ruling in Rahimi could provide important legal precedents that impact the Gazzola case and other similar lawsuits. The outcome of Rahimi is expected to influence how lower courts interpret and apply the Supreme Court's decision in Bruin. The Second Circuit, in its review of the CCIA, distinguished the new law from the earlier restrictions struck down in Bruin, suggesting that Bruin's standards did not apply to the CCIA. This reasoning could be reconsidered depending on the court's interpretation in Rahimi. The broader context includes multiple cases challenging the CCIA and similar laws in other states. The Supreme Court's action or inaction on these cases can shape the future of arms control and Second Amendment jurisprudence in the U.S. Legal experts and advocates are closely watching these developments, anticipating that the court's decisions in one case will set significant precedents for others.
When did Congress pass a law saying pistol braces qualified? This pistol brace was sold in 2012. A guy walked into a gun store, bought it legally, walked out of the gun store with the pistol brace.
And so you had to implement this rule. This brace is exempt from your rule?
Supreme Court's initial refusal. In January, the Supreme Court chose not to overturn an order by the U.S. Court of Appeals for the Second Circuit, which temporarily allowed New York to enforce a new concealed carry law amid ongoing challenges. Justices Samuel Alito and Clarence Thomas noted that challengers could return to the Supreme Court if the Court of Appeals didn't resolve the disputes promptly. The issue is now back before the court, raising questions about whether the Second Circuit's decision in December, which favored the state early in the litigation, violated the Second Amendment. 2 years ago, in New York State Rifle and Pistol Association versus Bruin, the Supreme Court struck down New York's previous concealed carry law. This landmark decision changed the landscape of the Second Amendment by establishing that restrictions on arms can only stand if they are supported by historical precedent. However, the court did not specify which historical periods should be considered. In response to the Bruen ruling, New York Governor Kathy Hochul convened an emergency legislative session to pass the Concealed Carry Improvement Act of 2022. The previous law required arm owners to show proper cause for a concealed carry permit. The CCIA, however, restricts permits to individuals of good moral character. Applicants must attend a hearing and provide extensive personal information. The CCIA also designates specific areas, such as schools, churches, and hospitals, as sensitive places where carrying concealed arms is forbidden. Furthermore, it limits concealed carry on private property unless the owner expressly permits it. Several groups of arm owners filed lawsuits in federal district courts in New York to block the CCIA. They argued that the state ignored the Bruen decision by passing a law similarly detached from historical precedent. The lower courts agreed in part, putting some provisions of the law on hold. New York Attorney General Letitia James then appealed to the Second Circuit to reinstate the law, while litigation continued, and the court agreed. When the Supreme Court refused to suspend the CCIA again in January, the Second Circuit expedited oral arguments. In December, the Court of Appeals issued a 261-page decision modifying the lower court's rulings that had halted parts of the CCIA. The Second Circuit, recognizing it was at an early litigation stage, concluded that the challengers were likely to succeed in arguing against the provision allowing concealed arms on private property open to the public only with the owner's consent, as it violates the Second Amendment. The court dismissed the state's attempt to relate this provision to 18th century hunting bans, noting that the CCIA's goal of public safety isn't comparable to poaching. However, the Second Circuit upheld other parts of the CCIA, lifting portions of the lower court's rulings that invalidated restrictions on carrying arms on private property not open to the public, bans on arms in sensitive locations, and much of the good moral character requirement. The court found that post-Civil War arm regulations cited by the state might historically justify these provisions. It sent the cases back to the district courts for further proceedings. In Antonyuk v. James, challengers led by New York resident and concealed carry permit holder Ivan Antonyuk requested the Supreme Court to review and reverse the Second Circuit's ruling. They argue that the relevant historical period for the Bruen history and tradition test is the late 18th century, when the Second Amendment was ratified, rather than the late 19th century, when the 14th Amendment extended these protections against state infringement. The challengers claim this distinction is crucial because the Second Circuit would have to acknowledge that no historical precedent exists for the CCIA if it only considered the late 18th century. The ongoing dispute underscores the tension between evolving arm control measures and constitutional protections. The Supreme Court's decisions in these cases will significantly impact the interpretation and application of the Second Amendment in contemporary contexts. As the litigation proceeds, the balance between public safety and individual rights remains a contentious and pivotal issue in American law.
It's called the Second Amendment Preservation Act, or SAPA for short.
At least a lot of people in Missouri, they think this is great. The state of Missouri has told the federal government to go mind their own business. My kids shoot. My 7-year-old owns multiple firearms, so I'm 100% in favor of expanding Second Amendment rights to go after people who are violent in nature and are committing crimes in our community.
Overview of the Bruen case. In one of the most significant arm rights cases in over a decade, New York State Rifle and Pistol Association versus Bruen, the Supreme Court considered whether New York State's concealed carry law violates the Second Amendment. This case is the most consequential since the court's 2010 decision that invalidated Chicago's nearly 30-year ban on handarm ownership. The case, brought by the NRA affiliate New York State Rifle and Pistol Association, challenged a century-old New York law requiring arm owners to demonstrate proper cause to carry a handarm in public for self-defense. Local authorities have significant discretion to decide who receives a concealed carry license, even if applicants meet basic requirements. New York is one of 8 states, along with the District of Columbia, with may-issue concealed carry laws, where permits can be denied if applicants have not demonstrated a compelling reason to carry a weapon in public. In contrast, 17 shall-issue states grant permits with little to no discretion, and the remaining 25 states generally allow people to carry concealed weapons in most public spaces without a permit. Experts anticipated various outcomes ahead of the ruling. During oral arguments, many of the court's conservative justices seemed skeptical of New York's law, though they expressed concerns about public safety if restrictions were excessively relaxed. A narrow ruling might allow New York to maintain a licensing law but reduce the discretion given to authorities. A broad ruling could potentially declare all types of licensing for concealed carry unconstitutional, though this was considered less likely. The decision could have far-reaching effects, potentially prompting challenges to similar laws in other states. The ruling might also necessitate further legal battles to determine specific locations where arms could be prohibited, such as college campuses or crowded public events. A critical issue is whether the Supreme Court will adopt a text, history, and tradition approach for evaluating Second Amendment rights. This method, favored by arm rights advocates, argues that only regulations with historical precedents are constitutional. Such a standard could challenge many modern arm regulations, including prohibitions on arms in sensitive areas like planes or restrictions for individuals with domestic violence convictions. If the court applies this historical-only standard, it could reshape the legal landscape, leading to increased litigation over various arm control measures. Numerous Second Amendment cases are already in the pipeline, suggesting that the Bruen decision will likely spur further legal challenges and debates. That's all for this video, folks. We'll see you next time.